In some injury cases, it makes sense to take your case all the way to a jury trial. In most cases, it does not make much sense to take your case to a trial. So how do you know if your injury case is one that should go to trial? Well, first, let me tell you the story of Amy. Several years ago, before I started representing injury victims, I used to work as an attorney for insurance companies defending personal injury claims in court. One of the cases I helped defend at trial was Amy's car accident injury case. This was a clear liability accident injury case, meaning the driver who collided with Amy's vehicle was clearly at fault for the accident. The insurance company retained the law firm I worked at to defend the at-fault driver in court after Amy's attorney filed a lawsuit against him. The case lasted several months before trial. Amy was deposed, my client was deposed, doctors were deposed, motions were filed by both parties which were heard by the judge in court, and a mediation was held. Amy was offered by the insurance company who hired her firm over $10,000 to settle her case prior to trial. However, she rejected every offer and took her case to a jury trial. You see, Amy claimed injuries to her spine. She had had pretty significant past problems with her spine pre-existing the accident. However, months after the accident, she had a surgery to repair her spine. Her claimed medical bills alone were in the six figures because of the surgery. The case went to a trial. We had a doctor who performed an independent medical exam on Amy testify at trial that Amy's surgery was likely not needed as a result of the car accident. According to the doctor my law firm had retained, the accident caused minimal damage, if any, to Amy's spine. The surgery she had was not needed because of the accident she was in, according to the doctor we had testified to defend her claim. Amy's lawyer, of course, had a doctor testify as well, and that doctor's testimony linked Amy's surgery to the car accident. The verdict came in. I was nervous until the moment the verdict came in, and the jury ultimately awarded less than $10,000 to Amy. The jury did not link the surgery to the accident. So you think this means that I would recommend that someone in a position similar to Amy's should settle their case prior to trial because Amy would have been awarded more money if she settled prior to trial? Well, not necessarily. Let me explain. First, let me discuss what it takes to get an injury case to a trial. Just to go over some of the more significant events to get an injury case to a trial, I'll start with the pre-litigation process, which is the period of time the claim is pending prior to a lawsuit being filed. Note that many cases settle during the pre-litigation process stages. Prior to filing a lawsuit, typically during the pre-litigation stage, you gather all your medical records and bills from all your medical providers. You of course get medical treatment, possibly with several medical providers during this stage. Once you're done treating or reach maximum medical improvement, or at an earlier time, typically it is best to send at some point to the insurance company or defendant a written demand for a specific amount or for the policy limits. Many cases then settle at this stage for the policy limits or after rounds back and forth of negotiations. If there is sufficient insurance coverage or pockets to pursue, it certainly can be the case that many personal injury cases settle for a fair amount even before you have to file a lawsuit. Still, there are many cases where a lawsuit needs to be filed in order to get a fair and reasonable recovery on your case. If the insurance company is making you a low offer, consider filing a lawsuit. In my experience, the insurance company or defendant you are dealing with will make you higher offers at some point during the litigation process prior to a trial. Some of the main steps during the litigation stages include written discovery, depositions, motions heard in court, mediation, and medical exams. Not to mention all the emails, letters, meetings, and telephone calls along the way. The litigation process prior to a trial can last years. getting a case to trial can also be costly. Retaining experts such as doctors or liability experts is not cheap. Not to mention court filing fees, mediator costs, and the many other costs that can pop up along the way. So knowing a little bit about what it takes to get a case to a trial, what are the reasons to consider taking your case to a trial? One scenario where you may consider trial is when the insurance company offers what you believe to be a low offer, and you believe that you will be awarded more money should you take your case to trial. In Amy's case, she and her attorney clearly believed a jury would have awarded her more money if they linked the surgery she had to the accident. And maybe if her case went to trial 10 times, 1, 2, 3, or more of the juries during that time would have awarded her more money. You see, juries are just a bunch of strangers. They all have different thoughts, opinions, and experiences they have gone through. Nobody can always accurately predict what a judge or jury is going to do with any particular issue or case. Another scenario where you may consider trial is where you believe an insurance company acted in bad faith in not offering you the policy limits when you demanded the policy limits. So, what about the reasons not to take your case to a trial? If you get a fair and reasonable offer in your injury case, it's usually wise to accept that offer prior to going to trial, especially in light of the time and costs it takes to get an injury case to trial. I also usually would not recommend to a client to take their case to trial if the insurance policy limits are offered by the insurance company in a timely and reasonable manner. But as I hinted at earlier, if the insurance company acted in bad faith by not offering you the policy limits when the insurance company was presented with evidence that your claim is worth over and above the policy limits, you may consider taking the case to trial. So, I mentioned earlier it may not be a bad decision for someone in a position similar to Amy's to take their case to trial. In hindsight, it obviously would have worked out better for Amy if she accepted the settlement in her case prior to trial. What it ultimately comes down to when you are trying to determine if you should take your case to trial is the amount of risk you want to take when you factor in the possible reward on your injury case, with the possible reward being a big payday over and above the last offer made to you prior to trial. For Amy, the possible reward was big because if the jury determined her surgery was related to the car accident, they likely would have awarded her the large amount of her medical expenses she incurred for the surgery and possibly a significant amount of pain and suffering damages that comes along with the surgery, which would have resulted in a big payday. It did not end up paying off for Amy. I can't be certain, but my gut tells me that was the case because the jury thought the doctor my defense law firm retained was more credible than the doctor Amy's lawyer had testified at trial. If Amy's case was tried 10 times to 10 different juries, it was certainly possible she would have had at least one jury award her a large sum of money. If you have a similar case to Amy's, for example, maybe the jury might think your doctor that testifies at trial is the most credible of the doctors that testifies at your trial. If just one thing went differently for Amy, maybe she would have had a big payday. At the end of the day, juries and judges are hard to predict. Taking an injury case to trial is not an exact science. If you're willing to take a risk to possibly get a bigger reward than the last settlement offer prior to trial, then by all means take your case to trial. The thing is, how do you even know if the last, best, and final offer made to you prior to trial is a fair offer? Well, in order to know that, you must be able to calculate your damages sustained in your injury claim. And in this video about to pop up right here, I'll provide you with the tactics used by insurance companies and injury lawyers to calculate damages sustained in an injury claim. Lastly, if you've been injured in an accident in Kentucky, remember to don't wait, call Tate.